So you find yourself in a position where you had not nipped things in the butt. You hadn't resolved things at the early stage. Or you're just realizing, oh crap, there's a lot of things that were done that they're not doing a self-confession on because they think I can't pick it up. Or you haven't done your due diligence enough to pay attention to the subtleties, which happens. Or even if you did do your due diligence, it just didn't come up. But now you realize, oh crap, this has been lingering too long, and they're very comfortable. And they're going, all right, sir, all right, ma'am, we're going to go to trial now. Okay. Do a constitutional challenge to the case. Do all the basic stuff. Do your affirmative defense. Object and rebut the allegations. Put your affidavit of truth. But in the process of doing all of that good stuff, know that you have the ability to actually choose the jury that's going to be hearing the matter. This is presuming you're the defendant. A lot of people speak of the right to jury of your own peer, right to jury of your own peer. But what does that mean? Right to jury of your own peers, people around the same age as you, people with similar life experiences, similar occupation, similar nationality, and social political status. And most importantly, your knowledge of the Constitution. Your affirmative defense and your source of claims are most likely going to be backed by the state or federal constitution, regardless, depending on the one you choose to use. And if you're doing a jury trial, this is presuming that they're trying to do a jury trial. If they're not, then you must demand for one. And a jury trial, if the Constitution is the backbone of everything that goes on, then those jury have to be able to put the Constitution into consideration. That is where VoirDire comes in. Your ability to pick your own jury. If you are not afforded the ability to do so, that's an ex parte judgment right there. That's an ex parte proceedings. That is unconstitutional. If they're going to do an ex parte proceedings in a constitutional manner, they must first inform you that they're trying to go without you, and they must have given you notice of it within a reasonable amount of time. Another thing regarding the prerequisite steps you ought to take if you have not put in a motion to dismiss before all this, even when they're telling you, all right, trial date is set for a month from now, or we're gonna have a status check on what's going on before a trial date is set. And no matter how close they say the trial date is, you can always test the sufficiency of whatever claim they bring to you, and that is a motion to dismiss. And oftentimes when you challenge the constitutionality of the proceedings or the status, the statute, it automatically challenges the subject matter jurisdiction and the personal jurisdiction. That kind of puts a wrench in their gear also. So you should always put a motion to dismiss in, because that's the purpose. To try to dismiss it before even going to trial. Honestly, you should not even be going to trial in order to dispose of a case. 9 out of 10 times. If you really didn't harm anyone, and you really deserve freedom based on you knowing that you deserve it, and that you're not waiting for somebody to determine the course of your life for you, you should be proactive enough to even stop that thing from getting to trial. And the motion to dismiss is the way to do it. You can dispose the case before it goes to trial. But just make sure you have your evidence in, and make sure that you do a proper affirmative defense. So just like anything else, it's always important to know what the subject matter really means. And in this case, the subject matter is VoirDire. And you will later find out that VoirDire is not just about juries or jurors. It applies to any witness in general. And it's basically the process of you determining whether they are capable of telling the truth and that they are truly impartial. So VoirDire itself is a matter of constitutional importance. In Illinois, the 1870 Illinois Constitution states in Article 2, subsection 9, that all criminal prosecution, the accused shall have the right to appear, defend in person and by counsel, to demand nature and cause of accusation, and to have a copy thereof. Here it is right here. To meet the witness face to face, to have process to compel the attendance of witness in his behalf. This process that compels the attendance of witness in his behalf, meaning in a favorable manner towards you, that process is the VoirDire, determining their competency and their ability to tell the truth. In the federal version, it's in the 6th Amendment. It mimics the same verbiage. In all criminal prosecutions, the accused shall enjoy the right to speedy trial, public trial, by an impartial jury. Impartial jury. Process of determining their impartiality is VoirDire. So we hear impartial jury all the time, and then witness on his behalf. But what is the operation of law to that? It is VoirDire. Impartial jury of the state and district wherein the crime shall have been committed. This is blah 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 blah. Organization to be confronted with a witness against him. To have compulsory process of obtaining witness in his favor. How do you have a witness in your favor, or a jury in your favor? You got it. VoirDire. By determining their competency and their ability to tell the truth. You cannot have a jury or a witness in your favor or in an impartial manner if they're not even aware of the Constitution. If they don't go through the same functional, practical things in life, or have not went through the functional, practical things in life that you went through, they cannot relate to your state of mind as to the circumstance that got you in that situation, whereby you are now needing to do a VoirDire. Are you following? Does that make sense? A VoirDire is affirmed by the amendments in the Bill of Rights on both state and federal level. So do not let anyone fool you, because when you invoke this, they will try to fool you and act as though it's not, but it is. There it is right there. And even if these specific verbiages are not used in the Constitution, which they are, you can invoke your right to due process. You have the right to look at who are the people that are going to be basically making a determination about your life. That's due process. And even though we use the verbiage criminal prosecution, I think Rule 4, I'm not sure if it's the specific rule, don't quote me on this, but I think Rule 4 of Federal Rules of Civic Procedure, or towards the beginning, basically, it tells you that all proceedings are civil. So even if it's criminal, it's presumed to be civil. So this applies to civil cases also. If your ability to cross-examine witnesses or qualify them as witness, or to cross-examine the jury or qualify the jury, if it's just limited to just one type of cause of action, if you're just limited to just criminal, that's abrogated with due process. So keep that in mind. According to VoirDire's encyclopedia, VoirDire. VoirDire is a preliminary examination of a witness to ascertain whether he, being the witness, to ascertain whether he is competent. When a witness is supposed to have an interest in the cause, the party against whom he is called has the choice to prove such interest by calling another witness to that fact, or he may require the witness produced to be sworn in his VoirDire as to whether he has an interest in the cause or not, aka impartiality. We know it's impossible for judges to be partial. We know judges have bias. Of course, you have to prove that by memorializing the situation and just putting a notice or your affidavit regarding bias or partiality of acting judge so and so. Then memorialize the instance, make the claim, show that they acted in a certain way that's detrimental to you based on the fact that you're doing a constitution, you're invoking a constitutional secured right. That's the intent right there. And then put their lawyer credentials on record. But that's another thing. But nonetheless, VoirDire is to prove their impartiality. It puts the judge on the side, and it will probably be a good idea if you'd also put notice regarding the fact that even though the judge might try to limit the evidence that you're putting in, that the jury is going to be looking at, because they will do that. They will pull the jury to the side and limit the type of things that they get to observe. And if they don't, right off the bat, they stop them from being able to even see certain things. So when you attend that VoirDire, verbalize that fact onto the record and create notice of that as a paper trail. Send that to the judge's chamber. But the party against whom he is called will not be allowed to have recourse to both methods to prove the witness' interest. If the witness answers he has no interest, he is competent, his oath being conclusive. If he swears he has an interest, it will be rejected. You know how the judges swore an oath to the Constitution? This oath that the jury is going to be taking is sworn to tell the truth and nothing but the truth. And that's based on principles of due process, which goes back to the Constitution. So your main focus with this VoirDire is to make sure that the jury knows about the Constitution, because that is what determines whether they are competent as far as you're concerned. If you're making a constitutional claim, the competency that you're seeking is their understanding, at least on a minimal level, the Bill of Rights. Then make it very clear that this guy, this or lady, this acting judge have been impartial, and I need you to not be the same. Let them know. Though this is the rule established beyond the power of the courts to change it, meaning it's archaic, it's based on maxims of law. Though this is the rule established beyond the power of the court to change, it seems not very satisfactory. You know why it doesn't seem satisfactory? Because they can't manipulate it. That's why they try to pull them to the side and tell them, hey, don't say this, don't do this. Or they just limit your evidence. This is why it's important to not be long-winded with what you write, what you put on pen and paper. Besides, the everyday man and woman that act as a juror, the attention span, I admit my attention span is low. The everyday man or woman, especially if you're at North America, the attention span is horrible. So get to the point. And they wouldn't also use the whole excuse of, oh, burdensome paperwork, and they can throw the 12b6 on you right then and there. And that is too much paper, or I forgot what the name of this Paper Reduction Act. They can invoke that. And the jurors probably don't know much about that. They're just gonna go along with it. So do yourself a favor and don't be long-winded with what you put on pen and paper. It says the witness is sworn on his VoirDire to ascertain whether he has an interest which would disqualify him, because he would be tempted to perjure himself if he testified when interested. It might be going through your mind, well, if this guy is the same nationality as me, same age, and I'm seeking that he understands the Constitution, doesn't that mean he's interested? No, it's not. He's interested if your family member is interested. If he or she, the jurors, that is, that have financial interest in the outcome of the case, they're interested if they had anything to do with the crime itself to begin with. But the mere fact that you're seeking out someone's competency regarding the Constitution, or someone of your own peer, does not make them interested in the matter. Nonetheless, keep in mind, all governments are instituted by the will and consent of the people, and that will always stand regardless of any circumstance. But when he is asked whether he has such an interest, if he is dishonest and anxious to be sworn in the case, he will swear falsely he has none, and his answer being conclusive, he will be admitted as competent. If on the contrary he swears truly he has an interest, when he knows that will exclude him, he is told that for being thus honest he must be rejected. A suitable inquiry is permissible in order to ascertain whether a juror has any bias, and this must be conducted under the supervision of the court and be largely left to its sound discretion. See that? That discretion and that supervision of the court and the suitable inquiry permissible in order to ascertain whether a jury has any bias. It's the fact that they're going to pull them to the side and tell them what to do and what not to do. Expect that. That's how they interpret this. And that's how they act upon this. They construe this determination of the bias of the jury and their permission to regulate that as them being able to pull the jury to the side and say, hey, don't say this, don't do that, or here, just take this paper that we want you to see. So entertain that as not being a suitable inquiry permitted in order to ascertain whether the jury has any bias. Omission of substantive information that's required by the Constitution and the rules of evidence is not a suitable inquiry permissible in order to ascertain whether a jury has bias. But let them know that. Let the jury know that, and let that acting judge know that. And it goes on to say there is no objection in not allowing a juror to be asked as to his political affiliation and whether they would bias his judgment, in the absence of any statement tended to show a special reason for asking. A jury may be asked whether he is a member of a certain secret society. In other words, you can ask them if they're a British accredited registration member. Ask them that. If they are, then you already know what to do. You can disqualify them, because that other man or woman on the other end representing the state of, or whoever brought that claim against you, whoever is representing the defendant where you are the plaintiff, is most likely a British accreditation registered member. So it's an affirmative, it's a substantive right here. You can ask them if they belong to the British Accreditation Registry. And why and how is it considered secret society? Because they never talk about it. They don't want you to know. It's a secret. It really is. They go as far as to refer to British Accreditation Registry member as BAR, lowercase bar. So you're just thinking it's a physical bar. No, they're talking about an organization headquarters in Great Britain, foreign organization, whose members carry title nobility that's prohibited by Article 1, Section 9 of the United States Constitution and the Articles of Confederation. And who knows, maybe your state constitution might prohibit title of nobility. If it doesn't, then it's going to talk about corruption of blood. So ask them whether they belong to secret societies. Make it very clear that you're referring to the British Accreditation Registry. So it goes on and continues to say, or has ever belonged to the Committee of 100. The court may assume an exclusive examination of jurors, though it is the better practice to allow counsel to examine. Now, if you're not using, now when they say counsel, they're not using the word attorney or British Accreditation Registry. Counsel just means somebody who you're going to consult regarding something, whether it's a next friend, whether it's a trust member that you belong to, anyone that you can consult regarding something. But oftentimes the other party's counsel is an attorney. So bring that up too. So in summary, therein lies the general explanation of VoirDire or VoirDire. And here's another perspective. VoirDire is a French for to speak the truth. Recall, when it comes to evidence, the truth is how evidence is proven. The process through which potential jurors from venire or venire, whatever the fuck they call it. This is basically an equity. It's basically where you bring the sheriff in by way of the judge. But at law, it's basically the process of picking a jury. A panel of prospective jurors, a jury, is eventually chosen from the venire. It's basically that seat where they sit at, and then they mark 1, 2, 3, 4, and then you get to refer to them as jury number 1, jury number 2, blah blah blah. At law, that is. At equity, this word means and stands for a completely different thing. So, the process through which potential jurors from the venire are questioned by either the judge or a lawyer to determine the sustainability for jury service. Also, the preliminary questioning of witness to determine their competency to satisfy. Now, I've specifically brought up this other definition to bring to your attention that when you start looking at other things, you will see the limitation fixed onto judges and lawyers. Remember, Valentine's version and many other versions in case laws, which you can look up yourself, look this up, will let you know that you can use a counsel, aka next friend, aka trust member, aka guardian ad litem, whatever it is, and so long as it's not court appointed, aka court appointed attorneys. Know in your mind that the ability to interact or be engaged in VoirDire or VoirDire is not limited to judges or lawyers. Keep that in mind. The other important part why I brought up this specific definition is it mentions about preliminary questioning of witness. Those jurors are in fact acting as witness, but not in the sense that they're acting as witness of, oh, that guy down the street saw somebody bitch slap somebody and now you're coming to do a cross-examine, direct examination. No, not that. They're acting as a witness in the sense that they're witnessing the facts and the truth of the matter. The law is based on the judge. The judge determines the law. And of course, remember, you can be the judge also, depending on how you come in, if you know what you're doing. But nonetheless, the judge answers to the law, the jury, the fact. There's a maxim along those lines also. So when you see this word witness, know that it's not talking about cross-examination or direct examination of, did you see something firsthand? Can you tell us whether it's true or fact? And also know that the limitation of who can be involved in VoirDire or VoirDire is not judges and lawyers. So the questioning of witness is based on the qualification process to determine their sustainability, meaning to sustain something, suitability, meaning you can disqualify them or not. What you're going to do is you're going to bring a one paragraph explaining the reason why you're doing this and the importance of the Constitution, because your claims are going to be based on some treaty, Constitution, public law, public act, one way or the other. And what you're doing, why you're engaging a VoirDire or VoirDire is to make sure that they know about these things, or at least have the slightest idea about it. Because if you're trying to have, most juries don't know much, unfortunately, about how the world works. That's just the truth. And when it comes to the selection of juries, most attorneys use hypnosis. They look for the dumbest bunch so that they can do whatever they want, however they want. And that is where the whole situation of them pulling them to the side, excluding information and all that comes in. And you're going to put them within your first paragraph. They have opening statements and all that long-winded crap attorneys do. You don't do that. Just do one simple paragraph, letting them know the importance of the Constitution, how it applies to everyone, and that the intent here is to make sure that they understand it so that things can move forward accordingly to make society better at large and whatnot, and that it's their role. And let them know that they have the power and that no judge can tell them that they can't do this or not, and that it's not the judge's responsibility. So you create that list of questionnaires. Say, for instance, they're bringing you for some firearm issue. Of course, you know what your affirmative defense is going to be based on the Constitution. Second Amendment for the federal, whatever corresponding aspect within the Declaration of Bill of Rights in your state. They're bringing you for some crime of violence linked to marijuana and all that crap. Then invoke your sacrosanct religious sacraments. Let them know you were doing your religious rights and that nobody can be discriminated against based on religion, culture, ethnicity, national origin, all that stuff. So the first step, though, before the list of those questionnaire, which most of the time should be anywhere from 3 to 9 questions. Don't make it too long. Remember, most people in North America have an extremely short attention span. And the air and the atmosphere within that court building is so hypnotic in terms of fear that most people are well acclimated to and have grown into responding to ever so smooth and so quickly. So you want to retain them by being swift and to the point. The longer winded you become, the more confused and fearful they become. Assert knowledge in a very small and short manner, but most importantly, assert confidence in them that they have the power to change things. This is part of the whole people talking about the rights this, right that, power to the people. This is part of it. The reason why they've limited the definition of VoirDire into just judges and lawyers being able to participate and determine the suitability of juries is because most people have not been invoking this. Most people talk about, oh, jury trial, jury of your own peer. But how can you ever have an impartial and fair hearing if you're not involved in the picking of the jury, and the people that's opposing you are the ones picking it? So you're left out. You don't want that. The opposing lawyer, who is a witness and a third-hand witness to the man or woman bringing a claim against you, or the entity bringing a claim against you, doesn't have the same standing that's superior as you if you know what you're doing. Yet he or she is involved in the process of picking a jury. So should you. So you must beforehand, if you know trial is coming, you must beforehand put an affidavit and preponderance of evidence that shows that you do qualify to participate in VoirDire and to have counsels and other people present. Simple as that. And then by way of that, you propose a questionnaire, attach it as evidence, etc., etc. And it's game on. Now, in your respective jurisdictions, state, county, federal level, they will have jury questionnaires. Read it, understand the concept of what it is. And the summary is just going to be one paragraph explaining what they can do, what they can't do, and then the list of short questionnaires to determine their qualification or suitability. And here's another important part. Say, based on the answers, whether it's a yes or no and question answer, or a short response that you request from them based on their knowledge of the Constitution, specific to specific articles and specific sections. Don't even ask them about all parts of the Constitution, just specific parts that you're using to show your cause. If they know it, if they don't. If you realize most of them don't, this is how you get rid of them. This is what VoirDire really comes down to. Being able to pick and choose who's going to hear based on whether it's suitable or not. Don't limit it to the hands of these other people that are working against you. Be involved. So if you realize based on the answers that they respond to, you do something called strike for cause. So you move to strike for cause. You move to strike jury number blah 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 for cause, and then you explain the reason why, because they don't understand the constitutional principle. And keep in mind, by this point you would have done a constitutional challenge, so you're making it very clear. You have put in a certified copy of the Constitution. You're making it very clear that everything here is based on Constitution, and if the jury does not understand that based on what the Constitution stipulates, then they're not suitable and they don't qualify for it. The way that you move the court to invoke another VoirDire to say you picked 8 of them and 4 of them were not qualified or were not suitable, then to do another VoirDire to get 4 more is through a motion to strike for cause. Look that term up, strike for cause. Look it up, study it. But nonetheless, there's the summary of it. Other references like the 1828 Merriam-Webster defines it as a preliminary examination to determine the competency of a witness or juror. I'm telling you, when you invoke VoirDire, they're going to tell you, oh, that's only for cross and direct examination of witnesses that you bring in. Or only judges and lawyers can do that. No, it's not. No, it's not. It applies to jurors. It's not limited to just witnesses. And it applies to your counsels, your consuls, your trust members, your next friend, as we've earlier went over. So don't let anybody pull the wool over your eyes. VoirDire is one of those things that a lot of people don't invoke. That is the reason why it's dead. That is the reason why they're so comfortable to just limit it to just judges and lawyers. They've privatized it because people are not using it. Put VoirDire, put VoirDire, put it to use. It's right there. It's a tool that you can use. That is how you take the power back. That is how you link back to the public at large, the general public. Because now you're giving them power and you're letting them know what's going on, and now they're directly involved in the proceedings that's changing the everyday man or woman's lives. If you want, you can look for someone with the same religion as you. If you're invoking religious sacrament, that's fair. That's just. You can look for someone around the same demographic and age as you. You can look for someone with the same national origin. If you want, you can look for diverse jury. Whatever it is, you make that determination. The hardest part of this, though, I'll let you know what the caveat is. The hardest part of VoirDire is actually getting into it. But there are many things you can do through advisandums and interrogatories to hold them by the nuts, accept their oaths, all that stuff, and engage in some other, private contract outside of the public court record. Involve fee schedules in it, but it should be based on constitutional claims and preponderance of evidence that you can actually make that claim. If you think talking about all caps and your birth certificate is the only means for it, that's the quickest way to get your ass kicked. But nonetheless, best of luck.